let's talk about the legal system not as it looks from 30,000 feet to law professors, where everything can be fit together and rationalized, but how it looks at ground level to ordinary law-abiding citizens. I am reminded of science fiction author Arthur C. Clarke's famous observation that any sufficiently advanced technology is indistinguishable from magic. From ground level, our encounters with today's legal system as it actually functions are often indistinguishable from lawlessness. When the legal process is more costly than you can afford, it is indistinguishable from lawlessness. If you are engaged in a business and are prudent, you have acquired liability insurance that covers the costs of legal defense against a lawsuit. If you work for a corporation, you are shielded from legal liability under most, though not all, circumstances. But if you are an ordinary private citizen of ordinary means, you usually cannot afford to pursue a legal defense against an allegation that will take you to court. In the case of a criminal charge, you can hope for the best from a public defender, but in a civil case, you face a tough choice, even if you are certain that you have done nothing wrong and that the courts would eventually vindicate you. You know that you will be unable to recoup your legal costs, and that those costs will probably run well into 5 figures or more, not to mention the weeks, months, or years in which the litigation hangs over your life. Citizens of average net worth usually cannot afford their day in court. So, if the accuser, be it the government or a plaintiff in a lawsuit, gives you the option of giving in at a price you can't afford, you give in. When defending yourself against a wrongful allegation is not financially feasible, in what sense are you protected by the rule of law? Criminal law that is sufficiently removed from the concept of mens rea is indistinguishable from lawlessness. For centuries, common law recognized 2 requirements for a criminal act: a guilty act and a guilty mind. The legal terms are actus reus and mens rea. You not only had to do something wrong, you had to be aware you were doing something wrong. But the law also held that ignorance of the law is no defense. How could these 2 principles be reconciled? Because there weren't many laws. Most of the laws that did exist prohibited acts that were obviously wrong in themselves, malum in se, such as murder, rape, and theft. Other laws prohibited things the state decided to prohibit, malum prohibitum, that were not wrong in themselves, for example, sumptuary laws. But these were of a manageable number. Today we often haven't the least idea whether we have broken a law. Setting aside state and municipal law, which add hugely to the problem, so many things have become federal crimes that it is impossible to keep track of them. Through the first half of the 19th century, virtually all criminal law was defined and prosecuted by the states, with fewer than a score of crimes defined by the federal government. For example, treason or bribery of federal officials. By World War I, the number of federal laws had reached the 500s. As of the most recent count, in 2007, the federal code numbered about 4,450 crimes. We have seen an increase of about 50% just since 1980. To see the implications for the requirement of having a guilty mind, take a moment to list all the acts you can think of that qualify as malum in se. I doubt if you can come up with more than a few dozen. If you stretch them out, for example, breaking down taking other people's stuff into the various categories of robbery, petty larceny, grand larceny, burglary, and so on, and if you have a good imagination, you can perhaps come up with 50. There just aren't that many different human actions that are self-evidently wrong in themselves and warrant criminal penalties. It is possible to imagine how this comparative handful of acts might have different definitions in different federal statutes. There might be several laws prohibiting different forms of bribery, for example. But as generously as you try to estimate, it is inevitable that an extremely large proportion of those 4,450 crimes in the federal code are malum prohibitum. Not things that are bad in themselves, but things that warrant criminal penalties because the government has said they do.